Good afternoon, Club 17. We have a great program today, and we're going to kick things off with the Pledge of Allegiance. Please join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And now Jim Hudson is going to lead us in the invocation and four-way test.
All right, I'll just hold it. Let's pray. Lord, when I think about service above self, one of the words that comes to my mind is kindness. I love this quote from Dan Kelly where he says the effects of kindness are not always seen immediately. Sometimes it takes years until your kindness will pay off and it is returned to you. And sometimes you never see the fruits of your labors, but they are there deep inside the soul of the one you touched. Lord, as we go through our Rotary year, our club performs many acts of kindness. Some are very visible, but countless others are seen by very few. I believe that even an occasional act of kindness can change the way a person feels about life. May our individual and collective acts of kindness have far more positive ripple effects than even what we can ask or imagine. And right now, we also pray for your blessing on today's hybrid meeting while we're still using this format. May you in particular use Justice DeWine's comments to encourage, challenge, and inspire us as we learn about the way he serves our community. And we ask that you give him all the wisdom that he needs for the opportunities and challenges that lie ahead of him in the days, weeks, and months ahead. Amen. Now together, let's all remember and be focused on a daily basis our four-way test, which states, is it the truth? In all concerns will build goodwill and better friendships, will be beneficial to all concerns.
Seats. And Jim, thank you. And we have some announcements this week. And first of all, just a reminder that when you finish eating, if you could just put your mask back on, that would be great. And we have a heck of a lot of birthdays this week, I should say. And I don't know what was happening 9 months before today, but I can guess. March 16th, Bob Croskery and Jay Scherger. March 17th, Tim Hirschner. March 19th, Julie Calloway, Glenn McEachern, Uda Popke, Jack Scott, and Michael Villardo. March 20th, Mary Dicker and Steve Rosenzweig. And March 22nd, Rick Finley and Wes Botto. Let's wish them all a happy birthday. And I have some good news for all you Euchre players. Rotary Euchre is going to start up again in April. And I know a lot of people have been anxious for that. You probably saw that the CDC recently issued guidelines that says it's safe for adults who have been vaccinated to meet in small groups. So following that guidance, our Rotary Club Euchre group will resume play on Tuesday, April 27th, with the requirement that members or guests must RSVP and must confirm they've been fully vaccinated. Please contact Jeff Weir with any questions or if you'd like to host the group. And I know a lot of members have asked about Split the Pot. When can we get that going again? And we've come up with a great approach for that. So it's going to start on April 1st. If you want to be part of it, you need to contact the Rotary office the week before. And so by the end of March, contact the Rotary office. You can have $20 charged to your credit card on file, and that will buy you 4 chances for the following month. So by the end of March, if you'd like to, contact the Rotary office. They'll charge your card $20, and you'll be in the Split the Pot for 4 Thursdays in April. And the way it'll work is if you're here in person, if your name is drawn, you'll basically win the regular part of the pot, but the accumulating pot, you'll shout out a number, or if you're on Zoom, you'll text me a number, and each of the remaining cards in the deck has a number assigned, and we'll just flip the card. If it's the Queen of Hearts, you win the whole thing. If it's not, all the money stays there. You still continue to be in the drawings for the rest of that month. So that's a lot of details, but if you want to know exactly what to do, look at E-Raise, and I think it'll be a lot of fun. And another piece of good news, we are going to have a Rotary After Hours on Friday, April 30th at Taft's Brew House. That's probably not the wrong name. I think, let's see. Brewporium, I knew it was close. Taft's Brewporium. How many people were at the Brewporium for a Rotary Roadshow a couple of years ago? It's a huge space. It should be a lot of fun. Again, it's Friday, April 30th. Reservations are required by April 19th. Just contact the Rotary office. Any questions? You can contact Dan Grunberg. He's our Rotary After Hours chair. And a reminder on our special program this March of Save Local, Believe to Achieve. One of our Rotary priorities globally is growing local economies. This is a great way to help grow our local economy by buying a gift card at a restaurant or any other local merchant. You can donate that gift card to the Believe to Achieve silent auction to support 3 charities. And you fill out a form, let the Rotary office know, and they will buy a gift card of the same amount from the same business, and that will go into the Believe to Achieve auction. So it benefits the businesses, which is huge, and it also benefits 3 great charities. And now that we're getting close to spring, we're starting to plan some outdoor projects, and the first one we have is with the school that we've partnered with and helped this year, St. Joe's School in the West End on Ezra Charles Drive. They have applied for a USDA farm-to-school grant to start an agricultural program right at the school. They are basically proceeding with that, but one of the things they're going to need to do is build some garden beds. They're going to build raised garden or garden boxes, and we have an opportunity to be part of a project to help them do that. So on Tuesday, April 6th, the project will be to build 10 garden boxes, 2 compost bins, and 2 water collection barrels, and will involve some light carpentry work and moving a lot of dirt and wheelbarrows full of, you name it, all the required materials. So it should be exciting. It's a great way to help the school. We've been helping that school with the Fruit Bowl program of delivering fresh produce every week. We've been doing that for most of this Rotary year. This is an opportunity for students not just to learn agriculture, but to raise some fresh produce themselves. So great project. If you're interested, contact Bill Stilley. And again, April 6th. And members in the news, our Rotary corporate member, Jason Vaughn, the CEO of Frisch's, has made the Nation's Restaurant News list of the most influential restaurant CEOs in the country. Congratulations to Jason. And our fellow Rotarian, Kelly Shook, please keep Kelly and the Shook family in your thoughts and prayers as they mourn the loss of her father-in-law. And congratulations to our fellow Rotarian, Bruce Jeffrey, on Cincinnati Chamber's announcement of his membership in the 2021 Sea Change class, their premier leadership development program. Congratulations, Bruce. And next week we have a great program. It's the annual Jefferson Award. So please join us for that, either in person here at the Hilton or on Zoom. A wonderful program and a wonderful way to support local charities. And appreciation to everyone on the committee who's helped this year. So now I'd like to switch gears to today's program. We're very pleased to have with us Justice Pat DeWine of the Supreme Court of Ohio. And we know, for those of us who've been in the club, Justice DeWine was good enough to speak to our club about 4 years ago, and we're very glad he's back here today. He was elected to a 6-year term on the Ohio Supreme Court, and that term started in January 2017. He is known for the quality and thoroughness of his legal opinions, which reflect his strong belief in judicial restraint and his respect for the constitutional roles of the other co-equal branches of government. Justice DeWine has served at all levels of the judiciary in Ohio. Prior to his election to the Supreme Court, he served on the First District Court of Appeals, and before that on the Hamilton County Common Pleas Court. He also has a strong commitment to education and helping to preserve the rule of law through education. He's an adjunct professor at the University of Cincinnati College of Law and also teaches undergraduate courses as well. He's a graduate of the University of Michigan Law School, and prior to that, he graduated from Miami University, summa cum laude, and was also a member of the varsity track and cross-country teams. And after law school, he was selected for a clerkship on the U.S. Court of Appeals for the Sixth Circuit and served under the Honorable David A. Nelson. Justice DeWine understands the litigant's perspective as well, having practiced law for 13 years with one of Cincinnati's top law firms. He represented clients in appellate matters in Ohio and in federal courts across the country. And as I said, Justice DeWine was here 4 years ago, and as we were chatting this morning, he said he's already been to 2 other Rotary meetings this week. We appreciate the support. We appreciate you being out in the community. And again, welcome, Justice DeWine.
Great. Thank you all very much for having me here today. I'm always excited to be at this Rotary Club. As was mentioned, I had a chance, I think shortly after I was elected, to speak to you, and I'm pretty sure over the years, I think when I was county commissioner, I was here a couple times for a State of the County speech, and I think I spoke to you when I was on City Council. So it's great to be here among friends. I have spoken to a lot of Rotary clubs lately, but this is really only the second one I've been able to do live. So I also appreciate all of the organization. I know the hard work into organizing this and being able to do it in this environment, because I think this is much better than having to do it all totally by Zoom. So I appreciate the efforts. I want to talk today about the Ohio Supreme Court. I feel very lucky to be able to serve you on the Ohio Supreme Court. I love my job, and I wanted to tell you a little bit about how the court works. And I thought I'd do it a little different way. I'd take you through a case from the beginning to end. So that's kind of what we're going to do today. I'll try to be pretty quick and save some time for questions. But I guess I should start with how do you get to be on the Supreme Court? Well, unlike federal judges, we're elected. The reason for that is it goes back to our Constitution, which was enacted in 1851. And believe it or not, one of the big issues under the old Constitution was about the selection of judges. People were very unhappy that judges had been appointed by the state legislature, and they thought judges were too beholden to the state legislature. So some people said, okay, we'll fix the problem, we'll go to the federal model, well, the governor appoints the justices. But others said, well, the same problem, judges will be beholden to the executive branch. And so what was finally arrived at was that judges should be accountable only to the people. And to do that, they should be directly elected to the people, and they should serve a term of years, so if people weren't happy with the jobs we're doing, they could throw us out of office. And so that's the system we have. And I think theory is a pretty good system. Sometimes it's challenging because people don't know as much about the judiciary as maybe they would like to. So I think it's important that we do these kinds of things. So why do you care about the Supreme Court? Why does it matter to you? Well, for one reason, 90% of the cases are going to be heard in state courts. you hear all about the U.S. Supreme Court, federal courts, but the real workhorses are state courts. 90% of cases are going to be heard in state courts. In Ohio, the Ohio Supreme Court is going to set the precedent that has to be applied in every court. I think the most important thing that our courts do is they're the protectors of our individual rights and freedoms. We're guaranteed certain rights, as you all know, by the U.S. Constitution and also by the Ohio Constitution. But those rights really don't mean anything unless you have a court system that can enforce those rights and step in when another branch of government infringes upon those rights. Jobs in the economy. We don't think about courts as mattering to the economy, to job creation, but the reality is that without a functioning court system, people don't want to invest and do business in a state. It's having clear legal rules allows people to make decisions, to do things, to invest, to sell insurance, whatever it is, so that helps us to thrive. So you don't think of courts as job creators, but they're pretty important. Public safety. We all know that courts are where criminal cases are going to be heard. And finally, I think our courts matter the most when we don't think about them. Really, courts work best when they're kind of in the backdrop without being needed every day. You think about something as simple as buying a house. What happens, right? You write a contract, the seller accepts the contract, you set a closing date, bank loans you money, etc. Well, none of that happens unless there's a court system in the background, right? The reason that contract to purchase that home means something that you can rely upon is because if someone violates it, you can go to court to enforce it. The reason the bank can loan you money is because they know they can foreclose if you don't pay your mortgage. So even when we don't see them, courts become pretty important to how we function as a society. So let me shift gears now and take you through a case. I'll take you through it from the beginning through the Supreme Court, how it gets there, how we decide it. So I'm going to tell you a story. This is a story about two floral shops in Worcester, Ohio. One's named Worcester Floral and Gifts. The other's named Green Thumb Floral and Garden Center. And this is a story that started probably 2 or 3 years ago. The owner of Worcester Floral decided that she was going to go out of business. So she set about closing down. She was tired of selling flowers. So she started getting rid of things. She had a domain name, which is important for our purposes, WorcesterFloral.com. She didn't pay the domain name register, so that became publicly available to someone else. Well, while she was in the middle of closing down, her employees said, "Hey, I'd really like to own a flower shop. Can we work something out?" And I said, sure. So they worked something out where she bought all the assets of the business, paid her $1 for the assets, and opened up a new floral shop. Was Worcester Floral before. It became Worcester Floral and Gifts, LLC. Well, remember I told you that domain name lapsed. Well, in the meantime, someone else had bought that domain name. So if you typed in WorcesterFloral.com on a website, here's what you'd see. So the owner of Green Thumb took advantage of it being publicly available. She bought it. She worked it out, so it redirected to her website. Something that's not that uncommon, right? Most of us have been on the internet, and we've thought we were going one place and ended up somewhere else. Well, guess what? The new owner of Worcester Floral didn't think that was very fair. She'd bought the business. She was running it. And she thought she was entitled to use that website. So she demanded, or actually she sent her husband to talk to the owner of Green Thumb and demanded that they relinquish the name and let her use it. The owner of Green Thumb said, "No, I don't think I'm going to do that. But I'll tell you what, if you want, I'll sell it to you. I'll sell it to you for $2,500. Well, the owner of Worcester Floral thought that was outrageous. So instead, what do you think she did? She filed a lawsuit. So filed a lawsuit. Where do you file it? Well, you file it in common pleas court in this case because over a certain amount of money. So it's filed in common pleas court. Wayne County is actually where Worcester is, so Wayne County Common Pleas Court. And she said that the use of this WorcesterFloral.com violated a law called the Ohio Deceptive Trade Practices Act, which makes it unlawful to engage in advertising or a business practice that creates a likelihood of confusion or misunderstanding as to the source of goods or services. So there was no jury in this case. Nobody asked for a jury. Judge heard the evidence, and the judge ultimately decided this was not a violation of the law. So she's still not happy, obviously. So what does she do next? She appeals. So in Ohio, anyone has an automatic right to appeal. All you have to do is pay your filing fee, file a notice of appeal, and you have a right to have your case heard. It'll be heard by a 3-judge panel. We have different districts in Ohio, so where you are depends on what district you're in. Here in Hamilton County, we have our own district. Most other counties are multi-county districts. So she went to the 9th District Court of Appeal. In the Court of Appeals, 3 judges hear the case instead of just one. The idea in the appeals you should have more judges leads to more dispassionate decision-making. There's no evidence. There's no witnesses. It's just 2 attorneys arguing. You argue for 15 minutes a side generally, and the judges hear the case and issue a written opinion. Well, in this case, the judges heard the case, and they decided the trial court got it right. It was a 2-to-1 vote, so it was dissent. 1 judge disagreed, but 2 out of 3 decided the trial court got it right, so they affirmed. So what's the next step now? Supreme Court? Right. So so now the next step is she can appeal to the United States Supreme Court, except she doesn't have a right to appeal to the United States Supreme Court, or the Ohio Supreme Court, excuse me. I've elevated this. But unlike the Court of Appeals, where you have an automatic right to appeal, in the Ohio Supreme Court, you have to ask permission to have your appeal heard. So you have to write something called a jurisdictional memorandum, which says why this case is so important that it should be one of the few we'll hear. So in 2019, for example, there were about 1,100 jurisdictional appeals filed. We accepted 43 of those. So your odds of getting your case in are pretty small. And so we're not, as we say, we're not an error correction court. We don't accept a case just because we think the court below got it wrong. We're looking for cases that we think will have some statewide impact, generally where there's a disagreement about the law. Maybe there's a court Court of Appeals in Cleveland has decided this law one way, the Court of Appeals in Cincinnati has decided another way, and so we want to have uniformity in the state. So those are the kind of cases we're accepting, something where we think there's great public interest. It takes 4 votes to accept a case, so the 7 justices, a majority have to vote to accept it. In this case, we did accept it, so Euchre Floral got in. So what happens once the case gets there? Well, the first thing to do is file briefs. Each side files a brief. The party appealing files first, then the party who won below files a response to that, and then the party appealing gets the last word. I'll read all those briefs. Typically what I do is I try to read those briefs myself first, and then I also have a law clerk. I have 3 law clerks actually, but every case has a law clerk assigned to it. So my law clerk for that case will also read the briefs and write me a memorandum about how they think the case should be decided. So I'll read the briefs on my own, then I'll read their memorandum, and then I'll go back and forth with them. I may have questions. I may say I need to read some other cases. I may say I need to look at some evidence that was in the record. But generally, we hash it out, and by the time oral argument comes around, I have a pretty good idea how I want to decide the case. So after briefing, we schedule cases for oral argument. We'll typically have oral argument 4 days a month, maybe 4 or 5 days a month. So most people think as a judge I'm sitting behind a bench all the time, but really what I'm doing most of the time is sitting at a desk, reading and writing. Most of my time is spent reading briefs or writing opinions. Oral argument is generally 15 minutes aside. So you think about a jury trial might take 3 weeks. You get 15 minutes to argue in front of our court. And generally we're looking at a discrete issue, 1 or 2 issues where party alleges that the court got it wrong. So oral argument looks kind of like
Hear ye, hear ye. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
You may be seated. Good morning, ladies and gentlemen. Our first case is 2018-1814, State of Ohio versus Gerald Prendergast. For Mr. Prendergast is Victoria Bader.
Good morning. May it please the court. My name is Victoria Bader.
And typically what will happen is she'll get about a minute in and someone will ask her a question. And most of the time, with most cases anyway, is spent asking questions. People who think that you go into oral argument and you have a speech you're going to give to the justices are usually disappointed because it's more, we look at it as more of a time to get our questions answered. That's what our courtroom looks like. If you're ever in Columbus, I encourage you to visit it. We're very lucky. It's a great place. But things for the last year look more like this, and this is actually the case.
Our second case is 2019-322, Worcester Floral and Gift, LLC versus Green Thumb Floral and Garden Center. For the appellant, Ms. Audie.
Good morning, Your Honors, and may it please the court.
So like you, we're doing our, well, we're not doing a hybrid, we're doing all Zoom. We've done that for about the past year. It's worked out pretty well for us. I mean, for us it's easy because it's just attorneys arguing. It's a lot harder for our trial courts, which I really worry about, some of whom haven't had jury trials for a long time, because jury trials obviously are much harder to do with bringing jurors in and evidence and witnesses. So I worry about them. For us, I miss doing the live oral argument, and I'm very anxious to get back to it, but I don't think it's been a problem. It hasn't affected our schedule. It really hasn't affected the information that we've got. And in fact, I think that this has been a challenging time for our court system, but it's also a lot of judges have learned to do things with technology that they never would have learned to do before. And I think there are some things that we can incorporate going forward to make the legal system more efficient and, more importantly to people, is reduce the cost of litigation. So following oral argument, we huddle. We all get together. We go back to our conference room, and we have to decide how we're going to decide the case and who's going to write it. So you'll see there's a picture of our conference room there. The way it works is the chief will call a case. We'll have heard 4 or 5 in a day. So she'll start with one of the cases. She'll say what she thinks about it, how she thinks it should be decided, and then we go around the room in seniority order from the most senior to the youngest and all give our opinions. What's a little bit unique about it, and I grew up in a family of 8 kids, we probably should have tried it there, is that we have an absolute rule that you can't interrupt anyone the first time around, which seems kind of easy, but it's actually really hard to follow. At least it's hard to follow for me because I always want to jump in and explain why someone else has got it wrong or what they're missing. But it's very strictly enforced. We do that, and then once we get all the way through, then it's kind of a free-for-all. Everyone can kind of give their opinion until we're done talking about it. Once we're done, we vote, start with the most junior, work our way up to the most senior. So the new guy or the new woman has to kind of show their cards first, and then we have a tentative vote. So it's just a tentative vote because there's no opinion that's been written yet. So then we have to decide who's going to write it. So to do that, we play a dice game. I don't know if have any of you seen a bottle like this? Apparently it came out of a bar somewhere in Cleveland. Seriously, and it's been around the court, for years. If you saw those die kind of things closely, they're all beat up and. I think originally it was some kind of game where you would roll a ball out, and that was what pool ball you had to knock in. But we use it to decide who's going to write the opinion. We all have a number. Everyone in the majority goes into the bottle, and whoever comes out is assigned to write the opinion. So my number's 2, and in this case, number 2 was the one that was rolled, so I got to write the opinion. So why do we write written opinions? Well, for one thing, as I mentioned, we set the precedent for all the courts in Ohio. So having written opinions is important so other courts know not just how we decide a case, but why. So they can see what facts are significant when they have another case and know how to decide the case. It's also important for the legitimacy of the court. What Alexander Hamilton said about the judicial system when he was trying to convince people to pass the Constitution and wrote the Federalist Papers is that we're the least dangerous branch of government because unlike the president, we don't have an army we can call out. Unlike Congress, we don't have the power of the purse. All we have is judgment. All we have is the confidence that people put in our rulings. But because of that, it's important that we explain why we make the decisions we do. So that's another reason it's not like Law and Order where the judges just announce their opinion from the bench, but we write detailed written opinions. So here I wrote the opinion. I upheld the lower courts. I said that the standard under the law was a likelihood of customer confusion. There may have been confusion initially when they typed the name into the website, but any confusion was dissipated by the time that they chose to order our products. They knew they were ordering from Green Thumb. So under the statute, which requires a likelihood of customer confusion about the source of goods and services, that wasn't illegal. Justice French disagreed. She wrote a dissenting opinion. She was joined by one other justice. When I write a written opinion, what I try to do is I try to think about the losing party. I want to write something that someone can pick up that's written in plain English and that they can read and pretty much understand and know that they may not agree with the result, but at least know there was a reasoned process based on precedent and the rule of law that went into it, not on the whims of judges. So that's kind of my philosophy when I'm writing an opinion. So I mentioned there's dissent. Why are there dissents? Why don't all judges see things the same way? Well, for one reason is, for us anyway, these are tough cases. We only take, as I mentioned, about less than 5% of the cases we're asked to. So we're only taking the hard ones where there's room for a difference of opinion. But also judges have different judicial philosophies. My judicial philosophy is I think our role is to apply the law as it's written. I just look at the plain meaning of what's in front of me and say I'm going to apply that language. Other judges may take a more expansive view of what the judge's role is. They might be thinking, okay, what's the intent behind this law? What's the best result? I think if you do that, you risk putting your own policy preferences ahead of what the law actually is. And if you want a system where everyone's treated fairly and justly under the law, then you need to apply the law as it's written, not think what it should be. But anyway, so last question I get a lot of times is, can Worcester Floral appeal? Can they go to the United States Supreme Court? Who thinks they can? 1, 2, 3. Who thinks they can't? Most people have no opinion. About equal. The answer is they cannot appeal. This is a question of Ohio law, so we have the last word. We cannot be overruled by the U.S. Supreme Court on a question of what the law of Ohio is. It's the law written by the Ohio legislature. If there had been a federal law involved, say, for example, the United States Constitution, if it had been a criminal case where a defendant had alleged that his home had been illegally searched in violation of the Fourth Amendment of the United States Constitution, there would be a federal issue, so there'd be no automatic right to appeal to the U.S. Supreme Court, but you could file a petition or writ of certiorari, they call it in the U.S. Supreme Court, and ask the court to hear the case. So let me just stop there. There's my contact info if anyone wants to, particularly people who aren't here. You can contact me, and I'm happy to answer any questions. Go ahead.
What was in all your judicial experience, lower court or Supreme Court, what was the hardest case that you had to adjudicate, and what made it hard?
If you could just repeat the gist of the question.
Yeah, right. So the question was, in the different courts I've served on, what was the hardest case I've had to adjudicate, and what made it hard? Cases are hard for different reasons. I think and I don't know if I can pick out one, but for me personally, actually the hardest cases I had were probably when I was a common pleas court judge, when I was at the trial level, because what I'm doing now is really trying to decide what the law is, trying to figure out what the law is, and those are pretty abstract issues generally. But when you're a trial court judge, it's all happening in front of you, and I thought, to me, the hardest types of cases were criminal sentencings when you had someone who'd done something that was wrong, but not, not all, in the extreme of things you see, not culpable in the same way that murdering someone was. Maybe you had a drunk driver who was second, third DUI who had killed a family, or so made a second DUI who killed a family of 7, and so you'd have the defendant's spouse or whoever, mother, father, testifying about why they were a good person. You'd have a family of the people who were killed, and those were just really hard things to balance. What's the right? You have a lot of discretion in those cases, and so those were the ones that I probably struggled with, kept me awake at night more than really the stuff I do now. Some of the stuff I do now can be really complicated and really hard, but it seems like if you work hard at it enough, there's a right answer you can figure out. For those kind of discretionary calls that you get in the trial court, there's no one set right answer, right? It's you've just got to make the best decision you can. So I thought those were the hardest cases.
So I just want to say, if you're in the room, you could either ask your question out loud and Justice DeWine will repeat it into the mic, or you can text it to me, which some people in the room are starting to do, which is fine, and I'll read it. And we've got a couple people that have just raised a question. One here in the room, John Farmeyer. Does the Ohio Supreme Court look to laws of other states to decide cases?
We don't necessarily look to the law of other states. What I will do is, if you have a similar issue, I'll look at how other state Supreme Courts or other courts have reasoned through that case, and look at kind of the logic of those decisions. I mean, we're not bound to follow the law of any other state. I mean, sovereign. We shouldn't say we're going to follow some other state's law, but I think we look. To me, I read out-of-state opinions all the time for their persuasiveness. I mean, is that logic persuasive or not to me?
What if Worcester was across the river, between Ohio and Indiana? How would that have changed? Because the internet issue is global, right? That's Ohio.
Right. The question is, would the result have been different if Worcester was in Indiana or in another state? Is that fair?
One florist with one side of the state, and the other was just saddled the state.
Okay, if one florist was on one side and one was on the other. Well, I would assume that the florist who was sued, the law would probably be sued in their home state. That would probably be where venue under our laws should be situated. So probably the law of that state would apply, and the law of that Supreme Court would ultimately make the decision.
Okay. And we have another question from a member on Zoom. Nancy Reese is asking, I would like to know what motivated Justice DeWine to move from previous courts to the Ohio Supreme Court.
That's a great question. I loved what I did. In some ways, being a trial court judge was the most fun job I've ever had, because if you're in a complex courtroom, you never know what's going to happen. There's just wild stuff every day, right? Like, criminal defendants run out of the courtroom, chased by the bailiff. It's just, it's just every day is different. But to me, being on the Supreme Court, I like the best because you have a much bigger impact, right? If you're a trial court judge, what you do is important, but it's important just to the parties in front of you primarily. And if you're a court of appeals, somewhat the same. But if you're on the Ohio Supreme Court, you're really making decisions that are going to impact litigants across the state. So to me, I think just having you have such bigger impact on what you do. I actually think that probably what I do best is the writing part, and so being on a state Supreme Court where that's important is for me works out really well.
Bob.
This is a wonderful case to talk about, because I think all of us are sort of rooting for the
Well, those are kind.
Repeat it a little bit.
So the question was that the person asking the question, assumption is that most people are rooting for, in this case, when they hear this story, are rooting for the plaintiff. And is the law poorly written? Should the law be changed because this is a law that was written? It was written before the internet. To me, that's really a policy decision. I'm probably not as convinced as you are that everyone's rooting for the plaintiff in this story. I think it kind of depends on kind of what's your view of the internet. I think people expect a certain amount of the internet. If you don't like where you are, you can hit the backspace browser and get out. Right? It's pretty easy to find where you are. The case might have been a little different. This case, I couldn't talk about all the considerations, but it's a little more complicated. It might have been a different result if this case had been a website like johndeere.com, right? Something that everyone knows. It's a trade that's particularly associated with a particular business. This one's a little easier because worcesterfloral.com, you could type it in because you've seen Worcester Floral, you've driven by there, you want to order flowers from there. You also could type it in because you want to find a floral shop in Worcester, right? So it's in that sense, this case is a little, there could be different results in other cases. We don't have those facts in front of us, but ultimately, whether the state legislature wants to give more protection to internet names, that's really up to them. There is another set of laws that doesn't apply in this case, but that could kick in. There's a federal law against cyber squatting, so there are laws against people just buying up certain names and then trying to sell them to people. So there are some protections there as well, but I try to stay out of whether this is a good law or a bad law. I feel like my job, that's someone else's job. My job is to apply it.
Okay, we have a few. I know Bob McElroy had a question a while ago. Bob.
There was not in Ohio, so that's why we accepted the case, so that there is now a precedent set. So if someone's in this situation, they know what the rules are. They know that if they want that domain name back, they need to negotiate for it. That there wasn't a precedent before. There weren't any cases that decided this issue in Ohio. There were some cases in other states and federal courts that decided somewhat similar issues. Most of them mostly went the way that we did, but there was nothing in Ohio. So that's exactly why we took it.
I know we have more questions in the room, but Steve Dreyfel in the room texted me a while back with a question. How is bail determined, and what discretion do judges have on the amount?
Bail is set by the judge. It may initially be set by a magistrate in Hamilton County, but ultimately a judge can make the determination as to bail, and it's really the judge has wide discretion how much bail they think is appropriate. Bail is supposed to be set, except in rare cases, to ensure someone's ability to ensure that someone will appear in court, but there's pretty wide discretion in how much bail will be set at.
Kind of a follow-up to John's example about cities that straddle the state line
point, can the appeal then go from the state Supreme Court to the U.S. Supreme Court?
Generally it cannot. There's a procedure where federal courts can hear what they call diversity cases, which involve citizens in different states, and those technically could be appealed, although the Supreme Court would never take one of those cases, I don't think. But generally, it's going to be one state's law, the other is going to apply, depending on. There's pretty complicated conflict of law issues when you have those things about which state applies. But one state or another state's law is going to apply, but also it could be, in certain circumstances, venue could be proper in a different state. So there are cases where Ohio courts hear disputes where they have to apply Kentucky law. But even those cases would only be able to be appealed to the Ohio Supreme Court.
Just have a bunch of questions, so I don't know who's next, but Angie Ferguson.
I want to be careful because I could possibly get a case where someone says their speedy trial rights were denied, or their rights were denied because of virtual formats. So I probably shouldn't answer that, just in case I do get one of those cases.
That's good. Andy Magenheim.
I just don't know. I don't know much about, Yeah, that's. I would assume there's certainly. I don't know why states wouldn't have authority over, wouldn't be able to regulate that, but I haven't really thought about it.
Yeah. So the question was about blockchain and what's the authority of the state courts to decide, or the involvement. So. Let's move to anybody else? Yeah, Molly Rydell.
Going back to that forest story, when you first started presenting the case, and you said that the green thumb office held the remaining $2,500. My first thought was, hey, we should take that.
Yeah.
So, do you have any idea how much money the plaintiff spent and how long it got to get to the answer she didn't want it, and then was the offer off the table for the $2,500?
Those are all really good questions, and the obvious answer is yes, she should have taken it, right? Yeah. I don't know how much they spent on litigation, but generally, a bench trial like that, and there wasn't a lot of witnesses, but I can't imagine it was less than $10,000. Same for going to the Court of Appeals, maybe $7,000, $8,000, but still, and probably at least another 10 in our court. So it was, they spent a lot more than they could have bought it for, and this is something lawyers understand that have seen it, is that people don't make the most rational decisions, or at least rational as when it comes to rational in terms of dollars and cents. There's other things that go into decision making. I mean, really, most civil litigation is a failure in negotiation because there's some number in almost all cases that people could arrive at that would make more sense than litigating in court. But sometimes it's really hard to get people to do that. When I was a trial court judge, particularly when I started, I thought I'm going to really work hard on mediating this stuff at the beginning so we get rid of some of these stupid lawsuits. And what I learned was that sometimes people just had to spend the money and write the checks to their lawyers for a while before it sunk in that this wasn't going to make sense. Even if I told them that at the beginning, they were so emotional about the case that they couldn't let that go.
Yeah. So I actually am going to come in with a question, which I usually don't do. I usually don't ask a question, but this is coming from a different angle. So I know you teach American government and politics as well as court system to undergraduates. For those of us, all of us who've lived through COVID, it's interesting to see kind of what's the jurisdiction, if that's not the right word, you can correct me, jurisdiction of federal authorities, CDC, versus Ohio Department of Public Health, versus the governor of Ohio, versus county health departments. I think from experience the past 12, 13 months, most of us probably have surmised how that works, but could you just give like a summary of how that fits?
This may be beyond my. This is not an issue I've thought a lot about, but generally states have powers over what they call police powers that deal with health and safety. So generally, most of those things are state functions, but the federal government, if there is a provision in the United States Constitution that allows the federal government to exercise that power, then whatever the federal government says is supreme. So, the difference between state governments and the federal government is federal government's one of limited powers. The Constitution, there has to be a power that is identified in the Constitution that allows the federal government to act. But over time, things like the Commerce Clause have been interpreted very broadly. So if Congress could say, okay, well, COVID affects interstate commerce, so therefore we're going to, I'm not saying we could do this, but we're going to mandate vaccinations for everyone. Arguably they could do that under the Commerce power. Of course, the courts would have to decide if they could or not. But unless, Congress acts under one of those enumerated powers, then the states have the authority to do whatever they want.
Very, very good. Well, thank you so much. Thank you so much. Great presentation, and I had told Justice DeWine ahead of time that this club likes to ask questions. So I'm glad you left a good amount of time, and very interesting to hear. And I have to say, having been here for the last 45 minutes, I feel like I was a UC undergrad, in a good way, being educated in American government and the court system. So thank you very much, Justice DeWine. Much appreciated. And in appreciation for coming to our club and giving us your time, we want to make a donation in your honor to the Rotary International End Polio Now campaign. So thank you. And while you only briefly mentioned it, the reality is, in being a justice and prior to that being a judge, you've helped educate a lot of people, not just in the classroom, but people who've clerked for you. And you've helped open a lot of opportunities for others in your various roles in government and the courts. Our theme this Rotary year is Rotary Opens Opportunities. We try to open opportunities to improve the lives of others, and you've done the same. And in recognition, we have a Rotary Opens Opportunities pin that I'd like to give you. So I just want to say a word of thanks to everybody who joined us today via Zoom or here in the room. Great to have this meeting together. And just a reminder, we've got a great meeting next week as well, the annual Jefferson Award. So please join us for that. And in the meantime, have a great weekend. Meeting adjourned.